Well, my clock says it's 10 o'clock.
Mine does
So
as well.
let's just go ahead and start. Because of my introduction, that'll make it easier for a few more people to log on if they need to. So I'll just say hello and welcome to NCompass Live. I'm Sally Snyder and I'll be your host today. And NCompass Live is a weekly program or webinar, whatever you want to call it, that we provide almost every Wednesday of the year with different topics that have something to do with libraries and librarians. So there's all kinds of libraries out there and there's all kinds of librarians. And so we have different topics that will be of interest to people. Some days it might be something that is not on your radar, you're not interested, that's fine. Also, if you're attending but you couldn't come during the live production, which is today, you can watch a recording, which at the end of the show, I'll show you where to look for that so you can find ones that you might be interested in. So sometimes we have people from the commission giving our presentations, and sometimes we have people who are not from the commission, and that's who we have today. We have Dr. Chris Haeffner from Lincoln Public Schools, and I am now going to make her a presenter so that she can share all kinds of things with us. Okay, now I just messed everything up. Oh, I see. I think I have to do it like that. There we go. Make presenter.
There we
Okay, so
go.
you should now have power.
Um, Let me see here. Let me make sure I've got, there we go. There we go. Uh,
Yes, I can see it now. Thank you. And I'm going to mute myself, but I will be watching the question. I forgot to say this. If you have questions, click on the question mark at the top and you can type in your questions since we're not going to give you um, microphone opportunities. And then I will occasionally interrupt Chris with a question that someone has asked. Just so you know, I'll try to be gentle though.
well, thank you, Sally. And do please insert those questions whenever they pop up because I have a terrible time monitoring both the feed and my slides. So I appreciate that. Once again, I'm Chris Haeffner. I'm the Director of Libraries for Lincoln Public Schools. So we have a total of 62 libraries that I manage and supervise. Um, I've been a librarian for 25 years now, and in my position for the last 10. And this presentation has come from a couple different sources, and I gained my limited expertise in this area due to some circumstances that came up in the last few years. Um, First of all, I was the president of the Nebraska School Librarians Association about 4 years ago. And that was in the days where in Nebraska, the concerns about book banning and book censorship uh, really hit hard in the legislative arena. And so, as the president of NSLA at the time, I had to really up my game and sharpen my chops in terms of how the law was written and how it impacted our school and public libraries. About the same time, I got the opportunity to attend a training from the American Library Association, where they brought a school librarian and a public librarian from every state to Chicago, where we spent 3 days in a pretty intense uh, professional learning situation where they provided as much background information as they could about the law and legal statute and how it impacts our decision making as librarians. So, most of my slides today and my talking points will directly impact schools and school libraries, but that doesn't mean that they aren't also applicable to our public libraries as well. Certainly, there are other laws that impact public libraries that I won't be speaking to because it's not my area of expertise. But hopefully you'll be able to take away today some new information and some talking points that you can put in your pocket and use from your professional planks as well. So that's just a little background. So we talk about law in the libraries because really our profession is grounded in those principles that that protect free speech and privacy when it comes to gaining knowledge and accessing information. Um, and as librarians, it's really important for us to have some background in how the laws do maintain privacy and access to information for our patrons, because we are called to be leaders, so that when we see some infringement or we suspect that access is being limited in whatever ways, we can be the protectors of that, and we can speak up and make sure that our patrons and our library boards uh, know what the law says and what our patrons' rights are, so that we can help protect them. ALA also calls us to hold this leadership role because, again, as librarians, it's part of our foundational responsibilities and our call to ethics, that we are the ones that make sure that every member of our community has the right to be informed, the right to access the important information to help them make decisions for their own lives, and to become educated about the world around them, regardless of the political landscape or the calls from the community to lean towards certain ideas and information. So first, we're going to speak about protecting user privacy. And there's a line that is a little bit different between schools and public libraries that we'll talk about here. But again, fundamental to who we are as librarians is the protection of our patrons and what information they are accessing, and what books and resources they are using. So we protect their confidentiality, and we make sure that they have access to all of those ideas and information. Um, the law is pretty great in this, in that the First Amendment in particular helps us be the translators to ensure that our students, our patrons, our parents have their privacy protected, and that, again, that they have access to a broad range of information, but we protect their confidentiality as to what information they are accessing. So we're gonna talk about three biggies that impact our youth. First of all, COPPA, SIPA, and FERPA. And in the school in the schools, these are really, really important because they do impact a lot how we can share information with our students, with our parents, and with outside entities. So COPPA is the Children's Online Privacy Protection Act, and it makes sure that any personally identifiable, pardon my tongue twisted, or my twisted tongue there, but any personally identifiable information for anyone under the age of 13 is protected. So when we talk about COPPA, we have to make sure that when we give our students or our patrons access to apps and websites and digital resources, we have to make sure that no personally identifiable information is being exchanged between that child under the age of 13 and those digital companies. Um, we and that sounds kind of easy to do. We just don't, But when we provide students access to an app or a resource, um, sometimes we aren't aware of what information that company is collecting, and so we have to be very, very cautious about reading the terms of service, and this is a biggie, about making sure that parents are giving consent before we allow students to access those online resources. Um, Parents have the right to say no when to whatever digital resources our students are using, especially if they know that those resources are collecting identifiable information. So at the school level, before we can provide a student access to any learning app, educational app, an app that's being used in the classroom, we have to have the parents' consent. And school consent cannot substitute for parental approval. And it would apply to public libraries as well. Any sort of management app or recording app that you're using, if that user is under the age of 13, you have to get the parents' consent, especially if they are collecting personally identifiable information. The next one is SIPA. SIPA is the Children's Internet Protection Act, and it makes sure that every school and every library has that internet safety policy, and that obscene and harmful content is blocked for children. Um, Schools also have to monitor student online activities, and this is a biggie here. Schools are required to then provide education about internet safety and appropriate online behavior. Um, the important piece there is who in our schools is providing that digital citizenship education. Uh, in many, many cases, it is the school librarian. And certainly in Lincoln Public Schools, this is one of our most important jobs as school librarians. And we have a whole host of resources and lessons that we use to make sure that every student, grades K through 12, is getting digital citizenship instruction. What we love about that is because SIPA is the law and because it is required, this provides us some job security as librarians because that instruction is required and we're the ones providing it. So SIPA makes sure that every kid is getting digital citizenship instruction and that there are safety nets in place so that they're not accessing harmful or obscene materials. Then there's FERPA. FERPA is the Family Educational Rights and Privacy Act. And what FERPA requires is that families have access to every educational record that is kept for their student. And you wonder, well, yes, but what does that have to do with libraries and access? Under FERPA, a parent has access to their child's library record as well at the school level, because the library record is part of their child's educational record. So anytime a parent walks into a school library and asks, what does my child have checked out? They absolutely, positively, 100% of the time have the right to receive and access that information. Um, and so, oh, pardon me. And so that I know is different at the public library, but because the school library record is part of the child's educational record, the parents always have the right to access it. Now, what isn't included in that is, I am so sorry. What isn't included in that is the school's responsibility for collecting their child's library record. And I believe I have this in my next slide. So library records are educational records, but unless a school policy requires it, there is no law that mandates a library to maintain a checkout history. So for instance, here at Lincoln Public Schools, for many decades, we maintained our checkout history because we could pull certain data from that we found useful and helpful as librarians. But if a parent walked into our library and said, I want to see every book my child has ever checked out, if we had that record, we would be required to share it with the parent. But if we don't have that record, there is nothing that we can share, and therefore the parent no longer has access to that history. And so we made the decision in Lincoln Public Schools to no longer maintain that checkout history. A parent can still walk in and ask, what does my child have checked out? And we would share that information with them because that is their right. But because we don't maintain a checkout history, we simply cannot give them a record of what their child has checked out throughout their duration in our school system. That was one tiny way that we could help protect our students' privacy while still meeting the requirements of FERPA.
Could I interrupt just a minute? Chris,
Yes,
we have
please.
a question. They are asking, is that similar to LB 390?
LB 390 requires us to let parents know what their child has checked out. My gosh, my phone never rings, and here it's rung 3 times. I'm so sorry. My gosh. LB 390 requires that we send communication to the parents about what their child is checking out currently. It does not speak to the historical record of what their child already has checked out. If that record exists, we would have to share it with them. But if no record exists, then there is no requirement for maintaining that record. Make sense?
Yes, thank you.
Very good. Thank you. And so we get to talk about then the First Amendment. And I am certain that all of us as librarians are familiar with our First Amendment right, which states that Congress shall make no law abridging the freedom of speech. And while the emphasis on that is the freedom of speech, it includes the right to speak and the right to receive information. That's pretty huge. That's the part that people fail to talk about. But the First Amendment applies equally to our right to speak and our right to receive information. And it applies equally to adults and children. So we find that the First Amendment gives us a lot of leverage as librarians, both at the public library and at the school level. One of the most important cases that tested the First Amendment law was Tinker versus Des Moines. And this was the case where back in the late 1960s, a group of students came to school wearing black armbands in protest of the Vietnam War. Well, the students were, or the organizers of this anyway, were sent home because of those black armbands and told that they could not protest in school. Well, they took it to the Supreme Court, and the Supreme Court led that these students' First Amendment rights were violated because students do not shed their constitutional rights to the freedom of speech at the schoolhouse gate. And if a school is going to restrict speech, including political protest and symbols of protest, that they can only do that if they can prove that that speech is causing a substantial disruption in the classroom. And so, how this applies to libraries, and particularly school libraries, is that, again, the students' right to not only speak freely, but to access information of all kinds is not limited to outside of school. And so school libraries definitely are protected here in that they can provide all sorts of information to students within the school walls. Another biggie is the Board of Education versus PICO. And this one, back in 1982, had to do with a school board that removed several books from their school library, from their high school and their junior high, claiming that these books were anti-American, anti-Christian, anti-Semitic, and just plain filthy. Stephen Pico, a student at the school at the time, challenged the removal of these books and said that the removal of these books and the ideas within them violated his First Amendment rights. Well, the Supreme Court upheld that claim and said that students in schools are protected by the First Amendment and that they do indeed have the right to receive information and ideas, and that books cannot be removed as an attempt to suppress ideas in the school library. So again, even if it is something that is not part of instruction that a school board may disagree with, a school board cannot remove books from the library just because they don't like the ideas contained in the book, in those books. And that's a biggie.
I have to interrupt you again. I'm sorry. We have another question that, and I don't know that you'll know the answer to this, but it's the person's asking, are public libraries required to keep checkout records?
I don't believe that any libraries are required to keep checkout records. It is, however, most likely written into the policies for that library by the library board. So before anyone turns off their checkout history, they would want to talk to their library board and make sure their board policies are reflective of whether that checkout history is maintained or not. There's no law requiring it.
I believe that. I agree with you. I believe that's true, but I don't have any access to that.
Yeah, you would want to check your library policies. So
good answer.
Well, I love to be, general about things and reference policy. So when we talk about free speech, that doesn't mean that anyone can talk, that can say anything without any consequence. There are unprotected categories of speech, and so we saw this come up in a court case way back in 1919 when somebody ran into a theater and yelled fire, and then tried to claim that it was, their First Amendment right to do so, when in fact it is not. There are unprotected categories of speech, which include obscenities, information or resources that are harmful to minors, Child pornography is never protected. False advertising is not protected. Defamation, threats that are real, and fighting words. Those things are not protected by the First Amendment. And so we do have to understand that there are lines that um, we can't cross under the First Amendment, but um, access to information is certainly not one of those. We found that in the case Miller v. California, um, the Supreme Court helped us to define then what is protected from what is unprotected. Now, in the Miller versus California case, Marvin Miller back in 1973 mailed to a whole bunch of people without their request um, advertisements, which included sexually explicit materials. And he was convicted under California's obscenity laws. Well, this case went all the way to the Supreme Court, and the Supreme Court upheld the government's ability to regulate obscene content. And they did that by creating the Miller test. Now, I didn't know what the Miller test was until I was the president of NSLA, and the Nebraska legislature was attempting to pass laws that would remove any book with any obscenity from our school libraries. And so I very quickly had to educate myself about the Miller test. And so this is what the Supreme Court says has to happen if a book is to be deemed obscene. So the Miller test has three parts to it. And in order for something to pass this test, it has to meet all three criteria. So first of all, the material has to be patently offensive, which means the work describes or depicts in a very offensive way sexual conduct that's specifically defined by state law. So the state law has to define the offensive material or the offensive content, and it has to be defined in law. The work has to appeal to prurient interest. Now, I can never ever say that word, and I had to look it up. But that word prurient means that it has to encourage excessive or inappropriate interest in sexual matters. So it has to be highly sexualized. And the test there is whether the average person applying community standards would find the work offensive according to those sexual matters, right? So the average person would have to say, oh, yes, the entire work is offensive. And then the third part is that it has to lack serious value, which means the work as a whole would have to lack any literary, artistic, political, or scientific value. Not any specific piece or part of it, but the work as a whole would have to be deemed offensive and lacking of any value. So in order for something to be offensive or deemed obscene, the Supreme Court says it has to meet all three of these requirements. Not only that, but this might be on another slide coming up, but it has to meet those three criteria by a court of law. So you and I can look at the Miller test and say, well, it might meet this criteria, it might meet this criteria, it might meet this criteria, and we can make our own decisions based on it. But a work cannot actually be considered obscene unless a court of law has says that it meets all three criteria. Now, This was tested in 1968 in the Ginsburg versus New York case, in which the they decided that obscenity applies a little bit differently to minors as it does to adults. And so, where there may be information and resources that would not meet the Miller test when it comes to an adult audience, Ginsburg versus New York says that states can treat information and resources differently when it comes to minors. And that materials must be viewed from the perspective of the minors who are being served. And so, interestingly, there it says that it has to be viewed from the perspective of the oldest minors served. And that came to play here in Nebraska as well. A couple of years ago, our Department of Ed was trying to make changes to Rule 10 and to define specifically what we could not include in our school libraries. Again, they were trying to make a definition of obscenity so that materials that they deemed obscene would be removed from our school libraries. But in their writing of their proposition, they claimed that the materials had to be viewed from the perspective of the youngest minors served. So that if you were in a school that served K-12, every resource there had to be appropriate for the kindergartner. And any ideas or information that weren't appropriate to the kindergartner could not be made available to the 12th grader. And so you could see where that could be very, very problematic. And certainly, thanks to Ginsburg versus New York, not legal either. So a work is deemed harmful to minors if its depiction of nudity, sexual conduct, sexual excitement, or sadomasochistic abuse appeals to that minor's interest in morbid interest in sex, if it would be patently offensive to adult standards, and again is utterly without redeeming social importance for minors. So they said that we can view that Miller test through the lens of how it would impact minors, but basically they kept the pillars of the Miller test in place. And that Miller test is a very, very powerful tool for librarians to be aware of and to learn more about, because it certainly stands in protection of the materials and resources that we select for our libraries, regardless of the audience. In 1987, a case called Pope versus Illinois came about, and this was one where again, a guy he was selling nudie magazines to minors, and the case was taken to the state or to the Supreme Court, and again, this one kind of restated that the Miller test as a whole protects both adults and minors. And the reasonableness standard is also in place here. I'm not speaking clearly. I'm so sorry. Let me back up a little bit. Originally in the Miller test, they said that that second pillar, that community standards could define what was deemed obscene or not obscene. In Pope versus Illinois, they said standards should be the same across communities. So whether I live in a very conservative small town Nebraska or a very liberal large city on the East Coast, community standards don't change. And so we can't define the Miller test by the community that we live in. It is defined by whether a reasonable person living anywhere would find those materials and resources offensive. The impact on our libraries from that Pope case was that libraries may classify materials and they may restrict access to materials based on the age of the patron. So we're not going to have adult content always available to our juvenile audience. It is appropriate and it is okay to make restrictions that way. And also, when we select materials, we can focus on age appropriateness while respecting intellectual freedom and privacy. So, for instance, our high school libraries in Lincoln Public Schools, we can say we will not put certain materials in our high school libraries, not because they're not fabulous books or because they don't have tons of merit, but based on the age of our audience, we can make selection decisions based on age criteria. And while a student might come and say to us, yes, but you're infringing on my First Amendment rights, we can say, well, we are a 9th through 12th grade library, and you may go to your public library to get those adult or more sophisticated materials. So we can balance what our minors need based on selection criteria and policies. Yes.
We had another question just addressing what you're talking about. And I suspect this is from a public librarian, but I don't know that for a fact. The question is, so for example, we carry some authors that are adult content, but we keep them in a separate room. Is that okay?
Yes, that is okay.
Thank you.
And I think I have another slide on that as well. Oh, but it's coming up. It's not quite yet. These are chronologically sort of ordered. Actually, if I skip to that one, I can come back to Counts versus Cedarville. This is where a library decided that they were getting too much pushback from parents about the Harry Potter series and the elements of witchcraft. And so they took Harry Potter books from the general circulation and only permitted students with parental permission to access them. So they're age-appropriate books, but they're requiring parental permission. The Supreme Court said that that is unconstitutional. If a book is appropriate for the age of the child, we can't limit access to it. And certainly this comes into play all the time in our schools, where I can't tell you the number of times I've gotten requests by community members and parents that books with LGBTQ themes or characters or information just be placed behind the counter or just be available with special permission from parents. And Counts versus Cedarville says that we can't do that. That would be a violation of our students' First Amendment rights. However, Pope versus Illinois says that if books are deemed are not written for children and they may be deemed obscene for children, then they can be put in an area where children cannot access them. Make sense? I do believe this is my final Supreme Court case, and then we'll start talking about other stuff. But ACLU versus Miami-Dade School Board, it seems like a simple case, right? The school board told the library to remove a book called Vamos a Cuba, A Visit to Cuba, because there were complaints that the book was outdated, that it was inaccurate, that it presented an overly positive view of the Castro regime. And so the school board had it removed from the library. And that was contested because somebody said, well, just because you don't like the content of the book, back to our other Supreme Court case, you can't have it removed. Well, this is different because the school board said the facts are inaccurate. It's not about opinions or even about the ideas in the book necessarily. It is factually inaccurate, and it doesn't reflect the educational standards that we have for our district. And the Supreme Court said, yes, we can remove books from our collections because of factual inaccuracies. And those books are not protected in the same way once they become factually inaccurate. And it does not discriminate against a viewpoint. It discriminates against factual versus inaccuracy. So that's a good one too that we get to use in our libraries often. So there is a removal test that we can apply here. It's constitutional to remove materials that are educationally unsuitable for students, if they're deemed vulgar or for the age of the student. That's constitutional, but it's unconstitutional to remove books because we just don't like the content of them. So it can feel like a fine line sometimes, but and it is based on sometimes how that removal is presented. But certainly it does give librarians and libraries a good foundation for making cases as to whether a resource can or cannot or should not be removed from their collections. We talked about Counts versus Cedarville. And finally on this topic, one thing that came up in Nebraska in the last couple of years was that threat of prosecution to librarians and to teachers who provided access to students or to minors to resources that some members of the community deemed vulgar or obscene. This was attempted to be written into law in Nebraska just a mere 2 years ago, which was very nervous-making for all of us. Certainly, there have been laws passed in states across the country that have written into effect this threat, that should a child go into a library and check out a book that can be deemed sexually obscene, then that librarian can be held responsible, can be fined or fired or otherwise even jailed for making those materials available to minors. What ALA has said is that while these threats are being made, to date, as of 2026, nowhere in the country has the step of prosecuting library staff been actually taken. And law enforcement officials have provided solid reasons why prosecutions like that are not supported by law. And so ALA says, yes, there are states making those threats, but those threats have been shown to be fairly empty as of now. because law enforcement simply doesn't find that they have a good grounds for prosecution in any of those cases. So while those threats are scary and real in places around our country, so far they have been found to be mostly empty. So that's good news. We still don't love them, but at least they're not gaining anything through them as of yet. So, what good librarians do when in the position of protecting access and protecting the privacy of our patrons, it is really, really important that we know our selection and reconsideration policies and that we know them really well. In order for a book to be challenged or banned from our systems, we have to make sure that those community members who are concerned are following the letter of our selection and reconsideration policies every single time, and that our librarians aren't making knee-jerk decisions based on threats or concern. We have to follow the selection and reconsideration policies that are in place. We also have to be attentive to trends and common challenges to intellectual freedom. Um, we Following social media is a great way to do this. Oftentimes, when I'm watching the social media feeds, I can predict what calls I'm going to get from the general public about books that they are concerned about. I know that community members are interacting with those social media feeds and that they're getting their book challenge ideas and content from social media. And so if I'm ahead of that and I know what they're talking about on those social media feeds, I can be better prepared. Being involved with our library association is important. NLA and NSLA do a ton of work to make sure that our libraries are being protected by the law, that our state senators are informed as they are considering making legislative changes, and that when legislative changes do happen, that our schools and our public libraries are in a good position to make sure that our patrons are protected as much as possible within any of those laws that are passed. So, but being part of your library association is incredibly informative and helps you stay abreast of all of the things that are in place to protect ourselves and our patrons, and to fight any challenges that we might have coming up legislatively. It's really important that we build relationships beyond our own libraries. Partner with your school library, with your public library, with libraries across the state, because the more we build those collaborations and those relationships, the better supports we can be for each other when tough times pop up. And my goodness, tell your library's story. If the community is only hearing about your library and the resources that you offer when there are challenges or when there's bad news, then there's going to be a bad taste in their mouth when they hear about or start telling your story themselves. We need to be telling our good news all the time so that we're building trust and open communication and insight into what you do and what you offer. In my last few minutes, I'm going to talk about a new law that is coming up that will impact all of us. And it is the Title II Americans with Disabilities Act. Now, Sally, I'm going to check with you. Do I have until 11 o'clock to finish speaking?
You can you can go after 11 o'clock if there's more questions or you have more to say. We say it's an hour, but it's a recording and we can go longer. If you have somewhere you need to be, you can
Thank
say,
you.
Sally told me I had to go. It's
Okay. I just don't want to take advantage of anybody's time. But I do want to make sure that that librarians everywhere um, are aware of this new part of the Americans with Disabilities Act, so that you're prepared to uh, make some organizational plans for your library. So most of us are pretty familiar with ADA, in which we have to make public facilities accessible to anyone with a disability. This law, was put into place decades and decades ago, and it's what led to curb cuts and elevators and all of those accommodations that would help persons with disabilities access our physical structures. Well, Title II applies the ADA requirements to our digital structures. And it says that all of our web content has to meet accessibility standards. Um, and it applies to all state and local government entities, including public libraries, hospitals, courts, and schools. I think that last line is supposed to say schools. So it's a little bit alarming to me when I speak to audiences that uh, there's been so little discussion around this new requirement. So again, what it says is that all digital content delivered via the web must be accessible to people with disabilities. And this was put into place over 2 years ago now. And it originally had a deadline of April 2026, like last month. So any community that was larger than 50,000, every one of their websites and every one of their resources that they provide online has to meet these digital requirements for ADA. If you're under 50,000, you had until April 2027, right? One more year to get everything updated and in place. Well, my district has been working like dogs, madly trying to get the thousands and thousands and thousands of online resources updated so that they would meet these new ADA requirements. And honest to God, it was like April 26th before the due date of April. I mean, it was days before our due date hit, and people could start submitting lawsuits against us. The government said, I think we might need more time, and we're going to extend this due date one more year. And so now we have one more year to get all of our poop in a group and all of our stuff updated to make sure that we are in compliance. And so let's talk about what that compliance looks like. So all state and local government departments will have to make sure that their websites and web applications are ADA accessible. Any PDF, spreadsheet, presentation, any digital document that is out there and available online meets accessibility standards. Any audio and video content that they provide must meet accessibility standards. And any online forms and applications have to meet those as well. So there are, okay, the first reaction that people have to this are like, oh my gosh, we don't even have any blind people that come to our library. Or, oh my gosh, we don't, there's only one deaf person in my school community. Why do I have to do all of this work? But when we think about it and get past that initial angry reaction, oftentimes there are a lot of people who benefit from this work. People who have mobility disabilities and may need to use a mouse to navigate all of their information. People with deafness or hearing loss, blindness or low vision, people with traumatic brain injuries, dyslexia, PTSD, autism, epilepsy, intellectual disabilities, and many, many, many more. This is not about, in the case of our school, one student who is in a wheelchair or one person who is blind. It's about the volleyball player who is in concussion protocol, or the colorblind student who is in every single classroom statistically. It's about the staff member who might have had rotator cuff surgery and can't scroll a document horizontally or use a mouse the way they always have. This work creates materials that are better for everyone, not just people with disabilities. In the same way that the original ADA law benefited certainly people in wheelchairs by creating curb cuts and elevator access, but also people who sprain their ankles, people who are pushing strollers, people who are riding scooters, people who have a bad knee. Those ADA protections for people with disabilities really make things better for everybody. And it's the right thing for us to do. We're librarians. How many of us have written into our mission statements access for everyone? Informational access to every single person. Well, as we apply new ADA requirements to all of our digital content, we are providing better access to information for everyone. So we can be mad about it, but it's who we are and it's what we do. So when we think about what those ADA requirements look like, as we're creating documents and updating older documents, at LPS, we're teaching our teachers and our librarians to look at 6 things, and they're not hard things. When we're creating PDFs and documents, we need to make sure that we are linking text appropriately. So instead of saying something in our text, our document that says, click here, we would say, click here to go to the Kareem Abdul-Jabbar website on his biography. Oh my God, I said that so wrong. But we describe what we're going to within the link so that we're giving that textual cue as to where that link goes. Easy, right? We have to make sure our documents have headings so that when somebody is using a screen reader, they can very quickly navigate from heading to heading to heading. That is as simple as highlighting and just making sure that that text is specified as a heading and the rest is body. Heading, body text, heading, body text. We have to make sure that the color contrast that we're using is visible to people with low sight or color blindness. You would be amazed how bad some of our things are. We can easily test for color contrast using free available online tools, but we have to make sure that our text is highly, highly visible according to color contrast. When we put an image in, our documents or our materials, we have to make sure that there's alt text so that if I scroll over that image, a screen reader would tell me what that image is of. Um, and that again benefits a lot of people, and not just those with low visibility, but people who are using their phones and the internet's not fast enough. Alt text will tell them what that image is rather than leaving a little blank question mark. Captioning our videos, this can often be done automatically, but we have to make sure that captioning is available. And then finally, when we're creating slides, that the reading order makes sense so that when a screen reader reads a slide, it's reading it in the order that the presenter intended, not the last thing first, but rather heading, body one, body two, maybe alt text. So they're not hard things to do. They are just things that we have to keep in mind as we're creating and updating our materials. So there's a little bit of urgency here. A lot of people still don't have any knowledge that this law is in place and that it goes into effect now in one short year. So we are legally responsible for making sure all of our digital content and all of the materials that we provide the public are accessible to everyone. After April 2027, the public can look at our materials with new scrutiny. And if they are not ADA accessible, we are liable for that. And certainly lawsuits may be filed if we're not providing things that meet those ADA requirements. Our lawyers at LPS have said that as long as we have a plan in place for training our teachers, updating our materials, and intentionally moving forward to make things better, as long as we have that good faith effort, then we really reduce our exposure to legal risk. So it's important for every public library out there to be talking about, how are we going to do this? How are we going to make sure that what's in place now becomes ADA accessible, and what we create in the future is automatically ADA accessible? It's a lot, and it's important, good work. That's what I'm going to end with today. That's a whole lot of information, but I hope that should you have any additional questions or you want to know more about how my team has approached any of the topics that we've discussed today, please feel free to reach out to me. I work year round at the LPS district office. You can reach me by email or by calling me at the phone number provided. I love to talk through these things, and the more conversation we have around them, the better we get at internalizing them and thinking reflectively about them, and having a better understanding of how all of us are approaching those legal issues that impact us as librarians. So thank you very much for your time and attention today. I sure appreciate the opportunity.
Wow, thank you so much. I agree. This is a lot of information and very well organized and explained. Really appreciate it. We do have another question. Now I have to get this other thing out of the way. Where can I look for more legal resources, such as the ones that you had on the screen? Is there a good place to look for
I
more?
my first the first place I go to kind of get myself up and going is the ALA's website. They have a really well organized set of resources that explain different aspects of First Amendment challenges and cases. So ALA is a great resource for us. Should you ever get the opportunity to attend one of their trainings, I know that they offer them several times a year. And I believe now they are all via Zoom. Certainly, if you have a chance to take one of their professional trainings on law in the libraries, uh, they bring in some of the very best experts from around the country to help prepare us to answer questions. So ALA doing great work as always.
Thank you. That's a great answer. I should have thought of that right away, but my brain is still trying to dissect everything you do, just digest everything you said. We also have a couple of thank yous from viewers. So again, thank you. And I'll reiterate Chris's offer that if you have a question or something that comes to you later, you can contact her. We have a recording going here, and that will be posted probably next week. And those who have signed up will receive an email saying, oh, the video's ready. And then also we'll have, I hope, Chris will be willing to share her slideshow and her contact information so that you can look at things again and contact her if you have a question that hasn't occurred to you yet or you're watching the recording.
I certainly will. I'm happy to share any of those resources that I have.
Now I'm just going to go. I shared the Nebraska Library Commission webpage, and I'm going to show you where to find all the NCompass Live information. You can use these flyouts, but I always have trouble getting from here over to there. So I most often use the search window here. And you just start with NCompass and there, NCompass Live. Just click on that, and the top item is, of course, all of our information on our NCompass Live page. So these are, excuse me, soon to be coming up in the future here. So you might want to sign up for another one. But also down here, just below that, it says Archived NCompass Live Shows. So you can click on that. And here is an extremely long list because we had this show. I'm not going to make everybody dizzy by scrolling all the way to the bottom, but I think it's been since 2009. Can that be right? Anyone who wants to drag their cursor all the way down there can sure take a look. So the reason I'm mentioning that is we still have every show that we recorded available to view for anyone, anybody in the country or around the world. They don't have to be a librarian if they want to learn something about libraries. There you can. But our caution is that the older the show when it was recorded, the more likely there is that there will be some broken links to things that had been talked about before. And the person who gave the presentation may not any longer be at the same location they were before. So you may not be able to find them if you want to ask them a question, just so you know that. And that's why we have these two different spots. Right now I'm clicked on Show Search All Archives. Over here you can click on Show and Search the most recent 12 months. Well, that's still, one show a week. Most months we have every Wednesday covered. Occasionally we'll have a week that doesn't work out. Something came up and the presenter had to reschedule, but not in time to schedule anything else. Or it was a holiday. And so we have these different ways you can search the whole batch of shows if you're interested. And I don't see any more questions for you today, Chris, so I'll just say thank you again. We sure appreciate your time, and that was a lot of information, and that is so helpful for us, for me, because I've been looking at things, but not as concisely as you have. So I'm just going to watch the show again and write all that information down to help me as well. Thank you. Thank you to everybody who attended today, and thank you to people who are going to watch the recording. We're sure glad you're all able to view this show. Have a great rest of the day. Bye-bye.